Good afternoon, everyone, and salam alaikum. My name is Rohit Singhal, and I am the Chief Executive Officer of Masin. And I thank every one of you for joining this webinar, which is going to talk about a very important topic of unlawful termination and encashment of bank guarantees in construction contracts, how to deal with them under UAE law. I have a great panelists along with me who are experts in the area of construction law and construction disputes. Let me introduce the panelists first. To begin with, we have Mr. Ali Zarooni, who is the managing partner of Horizons Law. Mr. Ali is founder and managing partner of Horizon and Company law firm. He is a highly accomplished and meticulous lawyer, having practiced law for 20 years. His area of specialization is primarily litigation and arbitration with a proven track record of success in dispute matters. He has represented some of the most prominent companies, establishment, and individuals before all levels of courts and various arbitration tribunals. He is a qualified arbitrator, registered with Dubai International Arbitration Center, and is licensed as a private notary public by the Dubai courts. Welcome, Mr. Ali, and thank you for joining this webinar. I have my second panelist, which is Mr. Shourav Lahiri. Shourav Lahiri is a barrister with Atkin Chambers and a specialist construction and international arbitration lawyer with over 20 years of experience. He represents clients from GCC region, Southeast Asia, East Asia, and India in onshore, offshore oil and gas, petrochemicals, power, infrastructure, and building sectors on the procurement, design, engineering, and construction of major projects related disputes. The leading legal directory, Chambers and Partners, described Shourav as a first-rate, a very experienced construction dispute lawyer, well-read and articulate, with substantial knowledge of construction-related legal issues. Shourav has been practicing in UAE for quite some time on the construction-related dispute. Then we have Mr. Rishabh Jogani, who is partner in MRP Advisory, which is a legal law firm in Dubai. Rishabh is an India qualified lawyer with several years of experience in construction disputes and arbitrations. In addition to construction law, he specializes in shareholder disputes, intellectual property, debt recovery claims, and real estate matters. He has represented clients in both domestic and international arbitration. He has done several arbitrations under ICC, LCIA, DIAC, and SIAC institutional rule. He has also managed complex litigation before the courts. As an experienced lawyer, he has managed hundreds of challenging disputes before various forums. Then, of course, it is myself. My name is Rohit Singhal. I am the CEO and founder of Masin. I have 25 years of international experience in construction disputes. I have acted as expert both delay, quantum, and on technical matters in more than 50 international arbitrations. And so now, without taking much of time, let's jump to the topic of this webinar, which is unlawful termination of construction contracts. I have come across in my acting as expert and acting as claim management consultant, that a lot of contractors and subcontractors in the region, and especially in UAE, are facing this peculiar problem related to encashment of bank guarantees, which could be either because of possibly unlawful termination or for some other reasons where there is an allegation that the performance of the contract has not been adhered to by the contractor. Now, the counter allegations of the contractor is that the performance was there, but because sometimes the claims, delays, etc., have not been analyzed by the employer and the engineer, therefore the encashment of bank guarantees is a wrong step taken by the employer. So today in this panel discussion, we are going to discuss about how to deal with the issue of unlawful termination and what is unlawful termination, and also deal with this important issue of what a contractor and a subcontractor can do in case they are put in a situation of a possibility of encashment of bank guarantee, which could be either advance bank guarantee or performance bank guarantees, which are typically the two bank guarantees issued by the contractors and subcontractors to their employer. So before I get into the intricate details, let me first take Mr. Rishabh from you, your opinion of what do you mean by unlawful termination, and what are the general causes for such kind of terminations under UAE law? Over to you, Rishabh.
Thank you, Rohit. So I think let's just divide the question into two parts, and I can answer it in that way. First is, of course, the definition of an unlawful termination, and it's rather simple. It's termination without a valid reason. Very often, your FIDIC contracts or construction contracts will always have a step-by-step requirement of when and how can termination occur. And it's an extremely important clause to incorporate because, although the parties when entering into the contract will not foresee disputes, but it's an important thing to consider, the way to exit a contract. Very often clauses are incorporated. Say, for example, there is abandonment of work, or there is unlawful suspension, or for any reason that the contractor is not complying with the contract despite notice. Those are generally the three grounds under which under which termination is resorted to by the employers. Um, those are the broader grounds and the most commonly used ones. There may be more. But say, for example, an employer does not follow the mechanism for whatever reason, or an employer unfairly says that there is delay and there is despite the delay being on the employer's own fault, um, and decides to terminate the contract. The moment he does that, he's doing so unlawfully. So it's always a question of dispute or whether termination was valid or not. But so long as there is justification under the contract, valid justification under the contract, the termination is lawful. If there is no justification under the contract or law to get out of the contract, it is a unlawful termination.
Thank you, Rishabh. So typically, what do you see, when there is an unlawful termination or termination by the employer? So what actions do you see the employer is taking? And what are the typical actions taken by the employer?
Thanks for the question, Rohit. So I've noticed that most often employers start talking about termination closer to project completion, unless there has been a complete abandonment, because employers are of the view that it'll take them probably a lot of time to go out there in the market and get another contractor to do the same job. It'll cost them more money as well. So employers will do this closer to completion date, but that's when it generally will happen, unless, of course, there is suspension, which is a completely different scenario. But what does happen is there is suddenly a barrage of correspondence. There is a lot more letters that are received, probably because the employer wants to make sure he's documenting everything before he decides to terminate. He's trying to make sure that his termination looks lawful before a tribunal. That's the first thing that will be noticed. Suddenly, a lot of things there will also be a little lesser cooperation from the employer on smaller issues. That's another trend. And of course, the last one, and which is I think the most important one for this webinar, is after termination, the employer will, in a lot of cases, try to go and pull the bond. He may threaten it as well to just put pressure on the contractor to try and settle the dispute. And this is the one that is something, of course, we will discuss further in this webinar. But this is something I've seen as the most commonly used method, that an employer tells a contractor that if you do not settle this, or you do not take X amount, or I will pull the bond, and you will not only not receive the money you claim from me, you will in fact be out of pocket, because the bond will also have to be paid by you.
I fully agree, Rishabh. In fact, when we deal as consultants with a lot of contractors, we come across a situation where the contractor and the subcontractor are sometimes hesitant in putting up claims or hesitant in entering into arbitration because they are worried that their bonds may be encashed. Now, at this stage, Shourav, moving to you. So let's say a situation is there where a contractor has finished almost 97, 98% of its work, and some minor snags or some snag points, punch list points are remaining. And there is now encashment call by the employer for the bond, which could be retention bond, performance bond, like that. So can a contractor or subcontractor approach his bank to say and request and put up a letter saying that, look, I'm almost finished with my job and this encashment of the bond is wrong. either maybe because of whatever be the reason, but this is wrong. So in such a scenario, do you see that banks will come forward and help the contractor and subcontractor and revert back to the employer saying that no, the encashment of bond will not be sort of.
Um, okay, so thank you, Rohit. This is obviously a predicament for the contractor because the contract, the bond is, it's basically an independent contract between the bank, which has or financial institution that's provided the guarantee or the bank bond, and the employer. And the contractor is actually, even though he has procured it, is not a party to that contract. So the contractor does not have, a way to ask the bank or to stop the bank from paying out. And traditionally, we know it's commonplace that banks will usually within 3 or 4 days of the demand being made pay out on demand bonds because it's just banking practice, banking committee. Now, so that's a generic term, but it's not so simple because there are situations where the bank needs to be a little bit careful. The first is, the question is the bond an on-demand unconditional bond, or is the bond a conditional bond? If it's an on-demand bond, which is the most common bonds we see in the UAE, then the bank really doesn't have to worry about anything else. It just pays out because that's what the bond terms of the bond say. If it's a conditional bond, which is rare, but not impossible, and it's based upon the fulfillment of a condition being different from just a demand, because of course an on-demand bond is also in a way conditioned upon a demand being made, and that's not the kind of condition I'm talking about. But a condition that is independent of the demand, such as a breach or evidence of breach or evidence of loss, then there is more allowance or opportunity for a contractor to interfere with or ask the bank to look closely at whether the condition has been met. But those are rarer occasions. The second area where a contractor can highlight to the bank is if certain formalities in the making of the bond have not been complied with. And when we come to Ali, I'm sure he'll have situations where the making of the call itself was defective in some way, rather than the bond being unconditional or conditional. So that is another area which a contractor can look at to try and persuade the bank to not make payment. The third area is if there is anything in the contract which is a precondition to the construction contract, which is a precondition to the employer calling the bond. A lot of people ask, what if the employer has to get certain determinations by an expert or an arbitrator before he can call the bond? That's what the contract says. But the bond doesn't say that. The bond is fairly straightforward. It's an on-demand bond. Can that be a situation where a bank can be persuaded to stop? Probably not. But if there is good, clear evidence of certain contractual steps not being complied with, at least it gives the contractor maybe a day or two longer, because the bank is probably going to refer it to its legal department to decide what to do. So that's not really a fail-safe measure, but those are the three sorts of areas where one can look at in persuading the bank to not pay on the bond. And finally, Rohit, the point you made when a contract is 96, 97% complete, very often, bond calls are made, and bond calls are made for 10% of the contract price at a time like that. So already you can see there is some problem with a situation where 3% of the work remains with retention being held, etc., and the employer calls 10% performance bond. 12, 13 years back during the financial crisis, this happened a lot, and the courts don't like that. So the courts will stop this sort of blatant misuse of a bond or overreach by the employer.
So Shourav, thank you. And you have now laid the ground for me to ask my next question to Mr. Zarooni. Mr. Ali, you have heard Shourav and you have heard Rishabh, and now a situation is there that a contractor's bond has been encashed and the bank has refused to put any kind of help to the contractor. Now, in such instances, what should a contractor or a subcontractor do? And do you think that UAE courts will come to its help or not? Over to you, Mr. Ali.
Thank you, first of all, and to give me the opportunity to be with the prominent panelist here, and thank you for the audience who's attending. As Shourav rightly said, there is certain things which the contractor can do it not through the court, which is related to the formalities of calling the bonds and everything. That is he's 100% sure. If the call of the bonds requires certain process has not been met, then things can be done directly with the bank. Talking about other legal measures, the contractor can take it. As per the applicable law here in UAE, you have to approach the court to obtain a freezing order against the bond call. That is, we call it an urgent application. Now, of course, there is a two different level of the court you have to approach, especially after the new arbitration law has been published. If the measure of the construction contract is carried with the arbitration jurisdiction, and some of the contract, it is not an arbitration contract. There is no jurisdiction for arbitration. So the people, sometimes they get a little bit messed up between the two type of contract. So if you are in the normal construction contract where you have an arbitration clause, as per the arbitration law, you have to approach the head of appeal court. So it is not an urgent application on the urgent judge on the first court. You have to apply it to the urgent application to the chief of the appeal court. That's some contractor make a mistake by approaching a different judges. So you have to approach the judge to take a freezing order. That's freezing order. It is very, very critical, and it is very time essential, because you have to draft it, you have to make the documents ready, you have to approach the judge. That's all within a span of 5 days maximum. If you are lucky, the bank will give you that ample time, because most of the banks here, they are giving you in 2 or 3 days maximum. And so you have to be ready to go there, and you have to take an order. Either if you have an arbitration clause, then you take it from the freezing order from the appeal chief justice, or you take it from the if you don't have an arbitration clause in your contract, you have to take it from the urgent application or urgent judge in the first court of instance. These two, it is available on immediate. Of course, with the UAE law, arbitration law, it's already contained also the provision for the tribunals to take a decision on urgent matters. Okay, but practically, till you reach the level you constitute the tribunals, that is a long time to be constituted. So everybody should, a contractor who are at the risk of their bond to be liquidated, they have to reach either the first court judge, urgent judge in the first court, or the appeal judge. This is two level actually the law is allowed.
Thank you, Mr. Ali. So now at this stage, putting the next question to you only, Mr. Ali, is in your experience, of being the managing partner of one of the renowned UAE-based law firms, have the courts coming positive and coming forward and have been giving stay or injunction towards the encashment of bonds? And what are generally the things which the courts are looking for when they give such kind of injunction towards the encashment of bond? I see a lot of questions coming from the people where they are saying that, how and what should be done in a scenario where a very small portion of work is remaining. Are the courts really seeing this from a favorable point of view or not? Over to you, Mr. Ali.
That is very, very important question, and I can understand all the audience they will ask, because that is the questions today in the legal market. What is how the court they are reacting to this kind of bond call, especially when with the market situation and the crisis happened and there is a COVID effect. So the court there is no one standard every court is taking. It is always dependent on the stage or the status of the project. It is always I always call it how you present your application to the judge to convince them that there is a high risk for a contract or a subcontractor to lose his right to recover his bond in addition to his outstanding. So it is always how you present it and what documents you have it. Now, of course, the easiest way, if you have a completion certificate, then the judge, you can approach him and say, I already complete the project. Why he encash it? Because he is not entitled. Okay, especially if the call was for advance bond or performance bond, because there is no merit why he will encash now after the project is finished. Okay, yes, there is a question mark maybe for the for the retention, for the maintenance period. That is another question, but it is very important to understand if we have a completion certificate or a handover for the project. Now, the courts, that is the easy way. Now, the judges, and I'm talking mainly because the main issues always was between Abu Dhabi courts and Dubai courts. I can see that the times change, then the judges, they start understanding the risk where the contractor they are involving, because there was a lot of incidents where the employer showing their unreasonable injustice why they are calling the bond when the project is 95% is finished. And more things which is making also to the judge clear now that there is a lot of unlawful call because for example, advance bond, the project in 95%, the advance bond is supposed to be actually returned back to the contractor, which the employer didn't do that. Okay, that is showing today there is a unlawful calls coming. Now the judges here as a human, they can understand what's going on based on the lots of application, but you need to have your documentation ready. You need to have to show, because the judge in urgent matters, whether it is a judge on the first court or appeal court, they have to deal with the application, an ex parte application, in a span of 24 to 48 hours. So you can understand that the judge sitting in his own chamber, he doesn't see the project, he doesn't know exactly what's happened on the site, he doesn't know anything except his limited knowledge will come out of your documents. Now, if you can be having a good document showing either a high percentage of completion or you have a completion certificate, that's good. If you have sometimes seeing, and I'm talking on the subcontractor, if you have an evidence that the main contractor has been terminated in the project, okay, and he's calling your bond as a subcontractor, you can show him that if he's out of the project, why he is blaming me now? I'm taking my bond because I'm his subcontractor. So you have to explain these kind of things. Now, Abu Dhabi court was very strict on accepting the application for a freezing order and issue a freezing order, because there was always on the impression that we have to see a completion certificate issued by the right authority to show that you have already performed your part. Dubai was more lenient, and they was look at it from the angle of is the call of the bond comparing with a completion, is it fair to call or allow the employer to liquidate this entire bond while the percentage of the work is left is very minor, okay, they balance it. And I think so today, both courts actually, they understand much better the situation of the market, and a lots of call which was unreasonably called for the bonds. So that this is the thing which we have to look at it. Your documents should be very clear. Whatever you have a taking over certificate is better than nothing, okay? Because even that taking over certificate is not a completion certificate, but it's showing you that the project has been handed over. The period of handover, for example, the project, if 1 year taking over certificate has been issued, and after 1 year he's calling your performance, that's showing that is unlawful way they are calling. They are harming me because their own benefit. So these kind of things you have to clear to the judge and make it clear, because he has to take a crucial decision actually to freeze the order, okay? Which is, I see it now today, the court is more accepting the ideas.
Thank you. Thanks a lot, Mr. Ali, for setting it completely clear to our audience that what should they do in case they are landed in such a situation. Now, at this stage, as you know, that banks are typically not giving much of time towards, for just, making sure that the money is not transferred. And it's a kind of a, quite a fight in terms of the amount of time which is available for a contractor to go to the court, get a decision, and go back to the bank and show them that I have got an injunction towards the encashment. So in your experience, how much is the typical time which courts are taking, in giving their decision towards the injunction, in case, all these documentation, as you said, are available?
Sure. I think based on the practice, it differs from a court to others, but based on our experience, Abu Dhabi court is very quick. So they issue usually the orders, whether positive or negative, in maximum 48 hours. Dubai, maybe because of pressure of lots of disputes, sometimes it take 2 days, sometimes 3 days, but that's all going in a span of these from 24 hours to 3 days. These kind of limit usually, and this is actually the purpose out of that decision, supposed to be urgent decision.
Thank you. Thanks a lot. And suppose in a scenario is there where, the lower courts are not, very conducive to the application of the contractor for giving and granting an injunction towards the encashment of the bond. So what should then a contractor do? How are the other levels of the jurisdiction, available to him, and what has been their approach?
Sure. Here we have to talk about one principle which a lots of contractor or some practitioners, they are unaware. The application for a freezing order, you can apply it as much as you want. There is no limit. So there is not, because you apply it once and it has been rejected, then you are not allowed to apply it fresh application. Okay. The only difference is you need to explain that you already applied before, but there is maybe some documents was not clear and we are clearing the situation. So the application, you can make it several. But if we are talking about one application, it has been rejected, then you have a right to go for a grievance. And here the grievance is difference between if the matters with the urgent judge on the first court of instance or with the appeal judge, because in appeal judge, or because there is an arbitration clause, then the jurisdiction for appeal court to decide on this urgent. The type of grievance, it's different. It's by application. You have to apply another application to the judge and he will decide it yes or no. There is no hearing for that. And in the first court, there is a hearing. There is a grievance, then there will be a hearing, and then there will be a debate on why the application has been rejected, and it will not be an ex parte. the other party will be joining that process of grievance. So he will attend, and he will put his objection officially to the judge why he thinks that his call is legal, okay, and he is eligible for encashment. So this two type of way you have to apply it in case you didn't succeed.
Thank you, Mr. Ali. Now, moving to you, Shourav, you have heard Mr. Ali talking about the provisions of UAE law, specifically when you move the UAE courts to, for possible injunction on the encashment. Now, besides the UAE court, which Mr. Ali has talked about, I also understand that there is another way, which by way of emergency arbitration. Because the most important thing is the time available from the call date when the call of the bond is there to the time when the money is transferred to the employer's account is very short. So what, as per you, can be a situation where an emergency arbitration can be invoked, and will it be helpful for getting an injunction on the encashment of the bonds?
Okay. So, picking up from what Ali was talking about in the courts, the first major difference that we all have to appreciate is that the court's jurisdiction is exercised over everyone within its jurisdiction. But an emergency arbitrator's jurisdiction is only on the contractor and the employer, or the main contractor and the subcontractor. They are the only parties to the contract under which there is an arbitration clause, which refers to rules, which then allows emergency arbitration. The bank is not party to any contract which has an arbitration clause. Quite often, most often not. There is no arbitration clause, and therefore there is no emergency arbitrator that can be appointed that will have jurisdiction over the bank. So that's the first major thing to think about. If you want to injunct the bank, an emergency arbitrator can't do anything. What can the emergency arbitrator do? It can take jurisdiction over the party making the call. So if you're the subcontractor, the main contractor, if you're the main contractor, the employer, so on. And what can the emergency arbitrator order? It can order either the person to not make the call. I think that's possible. Contractually, that's possible. Under the rules, that's possible. That's sort of a prohibitory injunction, which is not commonly used in the courts, because courts, as Ali pointed out, is an attachment of assets. It's a proprietary relief rather than a personal relief. Injunction is a personal relief. So the arbitrator, if the call has not been made, can issue a prohibitory injunction. If the call has been made, can possibly issue a mandatory injunction requiring the person making the call to withdraw the call. That can be done. Or if the money has already been paid, the emergency arbitrator can also issue a ruling requiring the employer or the main contractor, whoever has received the money, to put it in an account and not touch it, to some sort of a secured account. So these are the powers that an emergency arbitrator has. But if you look at any of the rules anywhere in the world, I find that a court application is much faster to get the relief. It has greater jurisdiction because it has jurisdiction over the bank, an emergency arbitrator will not have, than an emergency arbitrator. Now, there is a slight window of opportunity in an emergency arbitrator situation where once you make the emergency arbitration application, quite often your contracting party, that means the person making the call, will voluntarily not take further steps. So you may have achieved what you want to achieve without making an application to the court. And why would he voluntarily do so? Is because he will be in this arbitration, not before the same emergency arbitrator, but subsequently an arbitral panel. And if the emergency arbitrator decided against him and he did not comply, or he did something to waste the assets before the emergency arbitrator could decide, he would be put in a difficult position to explain his conduct. So there is the emergency arbitration possibility, which is under the ICC rules, several other rules. It's not under the DIC rules. The UAE arbitration law also doesn't talk about it. So if you have that power, there could be some value in it, but on the whole, not a great amount of value.
And Shourav, thanks a lot for this answer. What, as per you, under UAE law, are the decisions made by emergency arbitrator enforceable? Or should I
Okay. No, it's a good question because it's a common problem in many countries. Firstly, who is an emergency arbitrator? Is he an arbitral tribunal at all? The countries in like Singapore and Hong Kong, where the legislation has been amended to include in the definition of an arbitrator or an arbitration tribunal, an emergency arbitrator. Because otherwise you're having two arbitration tribunals. The UAE law
I think we have lost Shourav for the time being.
That's the first.
Yeah.
First
Shourav, we lost you in between.
Okay. I'm sorry. Can you hear me now?
Yeah, we can hear you. Can you just repeat your answer?
Yeah. So the first question is to ask is whether an emergency arbitrator is even an arbitrator under the law. The UAE arbitration law talks about an arbitral tribunal, does not expressly refer to an emergency arbitrator. Some countries, legislation, Singapore, Hong Kong do. So it's easier to characterize what an emergency arbitrator's award is. The second issue is it an award? Because an award is something that determines something fully and finally. Even a partial award determines the substance of what's before you fully and finally in relation to that. And a final award, you know what it does. But an emergency arbitrator's award is interim because it can be reversed by the final arbitral tribunal or the permanent arbitral tribunal formed. So I think the better thing, even though people call it an emergency arbitrator's award, the better way to look at it is an order. It's an order, an interim order. It's a nature of an interim order. Now, can that be enforced in the courts? Will depend, really. We know that certain EA awards from SIAC have been sent to India, and the Indian courts have said, no, we don't consider this anything that's enforceable. So you have to commence a separate Section 9 application, similarly in the courts here. So it could be the basis for the court making an order without legislative support of enforcing the award itself. In Singapore, you can, of course, enforce, or Hong Kong, you can enforce an emergency arbitrator's award or order directly. But I would think, subject to what Ali thinks, in the UAE, it may depend on the court saying, okay, I see what he has said. I can't enforce it directly because he's not an arbitral tribunal, but I can pass an order based on that.
So, Mr. Ali, what are your comments on what Shourav said? Are the emergency arbitration decisions enforceable under UAE law?
Sure. I just continue from where Shourav correctly said that we don't have in UAE arbitration law any emergency arbitrators, and yes, we have a emergency or urgent application, but in front of tribunals. Now, it is correct also that it is an order. It is not an award. Okay, so I think, in my opinion, it's if we take it as an order, though it is practically will be not that much helpful, because especially the process to enforce that order will take time, which is against the banks here, because they always will take an action quickly. Okay, which is practically is not the court is much better, but it's an order. It can be enforced, but it will not be an enforced. So it can be taken two ways. Either you take that order and you will use it on another application to the urgent judge and said, by the way, I am with the arbitration, emergency arbitrator, give me also order. That's showing that he studied my application and he feel that there is a legitimate ground for my request to freeze the order or freeze the encashment of the bond. So look at it as a extra evidence for you to give you more comfort as an urgent judge to give me the orders. Okay, that is one way. The other way, you of course the formality is taking a little bit longer, but you can approach and use a cabinet decision on UAE law and use it, because the cabinet decision on the civil procedure law saying you can enforce the arbitration award and the orders. So if you take the orders and go to the execution judge and use the cabinet decision, the new regime, which is implemented maybe a year or more, little bit, okay, that could also give you a fast track to approach the judge and make the execution judge to issue an order to the bank saying, hold the process because there is an emergency arbitrator decided about it. Okay, so that's two ways you can do it. I personally, because of urgency, I use that decision as evidence for me to go to the judge and issue it because of time issues.
Thank you, Mr. Ali. Yeah.
Rohit, can I just add one point to what Ali said, and perhaps this is something that could be interesting. There is some benefit in commencing an arbitration and asking for an emergency arbitrator's award, because one is, if you do get an attachment, you do have to commence an arbitration within a period of 8 days, if I recall correctly. So you've already done that. And secondly, I think from my discussions with Ali and others, that the court does take notice that actually this is a serious dispute. This is not a flippant application to stop the call on the bond, because there is already an arbitration started. So having started an arbitration, asking for an emergency arbitrator may give you certain ancillary benefits in your application to the court for an attachment.
Yeah, that is absolutely correct, Shourav. Thank you for saying that. It is showing to the judge that there is a serious dispute between the parties, and showing actually I'm not just trying to freeze to harm the others, but I am already in a dispute. So it's showing that legitimate dispute where you encourage the urgent judge to give you a freezing order, because end of the day, freezing order will not reduce the amount of security to the other parties, because the bond will be remaining there. So to keep balance, so he will see it that yes, there is a legitimate, if which situation is better, to freeze it or reject it. Of course, the judge, to be cautious, they will go for a freezing, because then till the main dispute is resolved.
Thank you, Mr. Ali. Now, before I close off this topic of encashment of the bonds, I'll just like to point out that in the event there is an unlawful termination and the bond is encashed, a contractor has the right to approach arbitration, which, as Shourav has mentioned, and there are various claims which a contractor can put. Specifically, in case of a situation of unlawful termination, what is most important for quantifying the claim is the extent of the work which has been done at the time of termination and what is pending payment. So, for example, if let's say 95% progress has been achieved and the contract is getting terminated, but out of that 95%, probably the payment is only made for 65% of the job, then whatever is the balance, there has to be a kind of a good industry practice is to have a joint report signed by both the parties specifying this is the quantum of work, this is the extent of material which is lying at the site, this is the extent of material which is being taken over by the employer, in order to then have a documentary evidence which can be used later on to by the contractor to claim its damages and losses related to unlawful termination. And then, of course, in case of unlawful termination, the claims which are raised should be what is your actual damage which has been suffered by the contractor because of the action of the employer in unlawfully terminating the contract. Now, before I move on further, Rishabh, a question for you is, what is the difference between termination for convenience and unlawful termination?
So, Rohit, that's a good question. And, the way to look at it is an unlawful termination, as I described previously, is termination literally for a reason that's not in the contract. A termination for convenience is a rather lawful termination, but on the basis that the contract provides it. And with some contracts, it's not very common in the construction industry to have these, because a contractor may not be very comfortable to sign that. But some of them provide that the employer may, with a particular notice or method, be able to terminate the contract. That's a very harsh consequence if I were a contractor, because that would mean that the employer just needs to give me notice of X date and be able to terminate. on that basis. So, that's the basic difference between the two kinds of termination. A termination for convenience is, as it's described, convenience of the employer. Sometimes a contractor may also want to, do so. Say, for example, the contractor is realizing that he just cannot perform, and a price escalation is not possible, and it's commercially becoming impossible to perform the contract. Whatever reason, the contractor may also rely on such a clause. It's rare, but it's an option that is available as well. Rohit, I think I'm on mute.
You're on mute there, right?
Thank you, Rishabh. Thanks a lot. Now, moving further, Shourav, to you. In the event there is an unlawful termination, can a contractor claim consequential damages, loss of profit, etc. under UAE law? I would like your views as well as later on Mr. Ali's views on this question.
Okay, thanks, Rohit. And picking up from what just Rishabh said, and Rishabh quite rightly said, unlawful termination is wrongful termination. Termination for convenience is lawful termination. And there is a distinction in principle between the two, but in concept, in consequence, they are very similar. So for a contractor who is terminated by convenience of the employer, he is being asked to leave for no fault of his own. Similarly, a contractor who is unlawfully terminated, he's being asked to leave for no fault of his own. And one would usually first look at what the contractual provisions state in the contract as regards termination for convenience. They give a guide to what kind of matters the employer must pay for. And you quite often say, well, that must be the same for unlawful termination, because essentially unlawful termination is you terminating me for your convenience. I've done nothing wrong. If the contract provides for, the contract would provide usually for recovery of profit, lost profit on the balance of the work. What you have not done, you have taken the work away from me, I priced for it, and I've not done the balance. Questions come as to what about recovery of overheads, unrecovered overheads, possibly unrecovered overheads. But then you also have provisions in the contract and in law which require or which prohibit recovery of consequential losses. So a big question in construction circles is loss of profit consequential, or is it direct? Because UAE law, and Ali is much more knowledgeable about this than me, allows you to recover direct and foreseeable losses. And in the concept of profit, it cannot be speculative profit. So certain profit. And what is certain profit? I'm not a construction man, but I think it's very difficult to demonstrate that I would certainly have made a profit on this. So recovery. So when you look at the provision, there will be no provision in the contract saying if the employer unlawfully terminates, he must pay X. No employer is going to draft a contract like that. So you look at the termination for convenience provisions. If there are no termination for convenience provisions, you look at the law and recovery of consequential losses under UAE law, apart from a situation of fraud or perhaps deliberate default, I think is very difficult. And even recovery of profit, which may be allowable or permissible under a contract for termination for convenience, without such a provision, may be difficult under UAE law. That's my understanding, but I defer to Ali's greater knowledge of this sort of thing.
Mr. Ali, your views, please.
Thank you. As the panelists said, yes, always that termination for convenient, it's not something which is the UAE law will, on the practice here in UAE law, will take it, because as Shourav said, what is that convenient? The convenient for the employer maybe is something which is against the right of the contractor, because the contractor haven't done anything. Okay, so in UAE law as a practice, the court won't take it that termination for convenient. Always the court, as a principle for a civil law system, always the actual damage is the main thing which the court will look at it. So actual damage in terms of the losses on profit, as again, any type of losses except now consequential losses, that is something else. I'll talk about it. But the actual loss of profits, the damages, the other type of damages, name reputations because they have been sacked for no reason. These all, it is permissible under the UAE law, but the threshold requires very high to claim. So you can't just put any claim without substantiate each and every part of your heads of your claims. If you don't put it, the court won't just take it speculated profit. Yeah, I think I should make 100 million on this project, but I didn't make it. The court, they would say, you have to show me with the evidence why and how much. If you didn't do that, the court here, actually, I always say, the civil law system is not a generous on compensations. Always very tough. Yeah, it's giving you the right, but it's always asking you a lots of requirement to take that compensation. That's, as rightly Shourav also said, there is nothing in the contract which said if you abuse your right or you illegal terminate me, you have to pay me X, because no employer will sign this kind of things actually. Okay, so the court to exercise and see whether you have a right for that claim or not, you need to be fully ready with the documents supporting your heads of compensation claims. If you don't have it, then the court may reject entirely your claim, not even a portion, because nothing has been substantiated. Now, consequential losses, that is, I didn't see the court actually, because the court very tough on awarding and compensation for actual damage. So imagine it now, if you come and said, in the future, I supposed to make this, that is consequential damages. That is something very difficult to prove it. You may say, yeah, but because the illegal termination and they call my bonds, then the bank stopped my facility where I was already bidding for another project, then I couldn't produce the bank guarantee there because of this. Then you have to prove all of this, particularly point by point, to the judge. Maybe at that time the judge, he will look at it, but it is very, very, very difficult exercise to do it. And I didn't see the court actually here actually taking that.
Thank you, Mr. Ali. And you rightly pointed out a claim for loss of profit is very difficult in terms of documentation. Generally, if a contractor has to prove that an X amount of percentage of profit he was to make, then he would have to demonstrate and a lot of evidence, like previous financial documents, past balance sheets, past profit and loss account, what was the estimate, how much is the actual expense done, and a lot of documentation is required, which when we are quantifying the loss of profit claims, all such documentation we come across, and that's the way we are able to quantify. But then also it is not a certain quantification, it's just establishing a causal link. And now I think I have got another 4 minutes to finish this webinar, but I have got a lot of questions and I'll pick some of them for all of you. Now, Mr. Ali, you said that, there are ways by which cabinet decisions, can be taken to the UAE courts. So have you come across a situation where the execution court in UAE has accepted an application based on cabinet decision? This is one of the questions.
Yes, that is, as I said, it is not a very long time. It's only about a year or so where it is come in force. And yes, the court actually take it in a very good way. And already there is a couple of application has been accepted. Whether we have done it, some of them, and there is another colleague on a different law firms. they went to the use the cabinet decision to enforce the order or the award issued by the tribunals, which was very good. There was a challenge in the beginning of that law because the judges they was not understanding, because that is really a shortcut to enforce the orders issued by because you have it was a new thing. But even that, there is certain requirement you need to have it on that order. It's like a tick box. You have to tick all the box. If it's all there, the court will take it. And I think the court now is much familiar, and they take it. That's not a lot of application has been made, but I think the court now, they are very well aware about it, and it is workable.
Okay, thank you. And one more question for you, Mr. Ali. Like under UAE law, can an employer unilaterally terminate the contract without the need of the court order?
In practice, you can sell a termination. Okay. Now, is that a termination acceptable? No, because the law is very clear. Either you mutual termination or by court order. So both of this is not. So the people, they said, we receive a termination. Yes, that is his wish to send you a termination and ask you to leave the site. But is that meaning that his right and just the contract is terminated? No, because the court has to decide it, because there's a dispute. It's not a mutual termination. It's a dispute. Then the court has to decide whether that termination, that letter of termination, which came to you, it was right, and they put an effect. And if the court accepted, then the effect of that termination go back to the day he sent you that termination. So the court has to decide if that is a termination or not. If they said yes, then it's go backwards to the date of termination, which a letter of termination is come.
And thank you, Mr. Ali. Now, last question for you, Shourav, as we are almost done with our time. One of the attendees wants to ask that, can they invoke emergency arbitration as well as go to the court in parallel? Will it be considered as right, or will it be considered as a forum shopping?
Okay, that's an interesting question, because there are situations under, for instance, the LCIA rules where a party has gone to the court and the court has asked, why haven't you gone to the emergency arbitrator first? So conceptually, I don't think there is any difficulty in going in both in parallel, particularly because the jurisdiction of the emergency arbitrator is very different from that of the court. So when you go before the court, particularly, I'm assuming you're talking about a BG call situation, you'll tell the court, look, I'm here before you because I can't get any relief from the emergency arbitrator on the bank. I'm going under the emergency arbitrator because that's what my arbitration rules say. I'm doing that process, but mainly for the person calling the bond. So conceptually, there is no difficulty in doing both, and there may be advantages in doing both.
So I think that brings us to the end of this webinar. I am really grateful and thankful to Mr. Ali, Shourav, Rishabh, and Legal 500 for this webinar. I'm also very thankful to the attendees who have taken out time to listen to us. And I have received a lot of questions, but because of the paucity of time, we couldn't answer. We will try to answer these questions through emails. We'll consult the expert panelists who are there, and we'll try to answer your questions through emails. Thank you, everyone, and have a wonderful afternoon. Thank you.
Thank you.
Thank you. Thank you.